Actually, thank you for taking my a little bit request. Now at the moment, in this pandemic days, actually we're
Yeah.
studying online, and my interest, my aspiration for international private law. I did research actually by seeing your bio. I got a little bit, how to say, inspired. Because of this, I got contacted to you. Thank you for taking my request again.
Thank you, Sanjar. It's a pleasure for me, and also I'm very interested in connection with my young colleagues from the Central Asian countries like Uzbekistan. As you know, we are brother countries.
Yeah.
Also, I'm curious to know about you. So now you are studying law, or did you graduate from the law faculty?
Now I am graduating sophomore course. I'm actually officially sophomore, almost the third year.
So third year.
Yeah, in the faculty of international law.
International law. Just a second. I'll just close the door. Just a second.
Okay.
So it is your third year right now in the university.
Going to be, inshallah, third year.
Inshallah. Perfect. So it is also very good to know that you, you know, in your universities, you are also taking specific private law courses, right?
Yeah.
Private international law.
Actually, we are generally international law. Because of this, you know, first of all, we are being taught at the moment international public law. And specifically next year, we are going to learn and start the international private law.
Perfect.
So that.
So this is Tashkent University, right? Tashkent University.
Tashkent State University of Law.
Tashkent State, yeah. Also, I know that you also established recently an arbitration center, right? Tashkent International Arbitration Center.
Yeah. It's been done for creating a good condition for investors, foreign investors.
Yeah.
Your
new president, Mirziyoyev, have very good progress for your country to attract foreign investors, right?
Actually, he's this year program and the municipal program, I mean governmental program, is in this development of last year's one. This year digitalization, last year one like creating a good sphere for investors. It was like this.
By the way, your English is perfect.
Not so.
I'm curious, how did you learn English that you can speak very well?
It is because of my granddad, you know. He was a little bit businessman and went to Malaysia and couldn't speak in English, and because of this, he forced me to learn English.
Yeah, I see. Perfect, Sanjay.
Could you just talk about your career path until until this time?
Yeah. In fact, I graduated from the law faculty in 2005. And even before my graduation, I started to work in a law firm in Istanbul. I'm still in Istanbul. So I can say that the most important thing is to determine the law firm that you will start, because the law firm is playing very determining role in your career, especially the field of law. So my first law firm was dealing with corporate law matters such as M&As, due diligence, drafting share purchase agreements, shareholder agreements. So in my first 5 years, I was just dealing with corporate law issues, not arbitration or dispute resolution. But I believe that all dispute resolution lawyers, arbitration lawyers, should be familiar with corporate law, because this is all about commercial disputes. Even if it's about investment arbitration, the investors are dealing with commercial issues in that state. So one arbitration lawyer should know very well the commercial transactions, international commercial transactions, and the relevant applicable laws, applicable international law rules for this dispute. So this was my chance to start in such a law firm. And also, I had English background, but when I started this law firm, then I became familiar with the, writing memorandums in English, writing briefs in English. But then, in fact, I didn't choose arbitration, but arbitration chose me. I had interest in, developing myself in international arbitration. By chance, in my second law firm, a case came to the firm, arbitration case, a good arbitration case. This was an investor arbitration case in 2010 against Turkmenistan. We had a Turkish client who had invested in Turkmenistan, and this was a dispute between this Turkish client and Turkmenistan. This was about a construction case. So this arbitration case gave me too much experience, and beginning from 2010, I started to get arbitration cases subsequently. I mean, after dealing with this investment arbitration case, I transferred to another law firm in Turkey, which is a very famous arbitration law firm in Turkey, Akıncı law firm. It's a professor's law firm, Ziya Akıncı, and I had a chance to deal with lots of investment arbitration cases in this law firm, Akıncı law firm. Actually, one of the arbitration cases was about Uzbekistan. You might hear Güneş Tekstil, Güneş versus Uzbekistan.
Isn't it Turkuaz one?
Turkuaz.
Yeah, we lost it, I think.
Yeah. Unfortunately, but fortunately for our client, because we were representing Turkuaz in that case, Akıncı. But as far as I know, Uzbekistan also has applied to the annulment proceedings. So now the annulment proceedings is going on before ICSID tribunal, ICSID center, arbitration center.
My teacher also took part in this case, and he said that
on behalf of Uzbekistan.
On the side of Uzbekistan. Yeah. He said Uzbekistan lost, but and he didn't say briefly because it was, governmental secret was a little bit in this, and he mentioned this, and so that we wasn't also so interested in it. Actually, I know that Uzbekistan side lost. For that, what he lost, I don't know this. So
the law firm is also very famous. Uzbekistan is working with White and Case. White and Case, the American law firm in that case. And of course, it is very good for an arbitration lawyer to be both on the side of investor and on the side of government. For instance, after Akıncı, after I left Akıncı, I started in another law firm, Lexis law firm, and now I'm the head of the arbitration department in Lexis law firm. And currently we are representing Republic of Turkey in 2 exit arbitration cases filed by some other claimants. The thing is, these are the firms from, I mean, the claimants are from England and Belgium. I can talk about this because this is not a confidential. This is not a confidential information. When you look at the exit website, you can see the cases. But the issue is the people, you know, who filed these cases, in fact, are Turkish nationals. So that's why we have strong objections to these cases, because, as you know, the first condition to file an exit arbitration case against a state, this should be a foreign investor in the first place. This should be a foreign investment. So in our cases, we represent the Republic of Turkey, and we have some objections that these are not foreign investors. These are not foreign investments. But of course, we will see. We will have hearings within this year.
Understand.
So, I mean, as you know, in order to be a successful lawyer in a field of law, first of all, you should love this field. So if you would like to be an international arbitration lawyer, you should have very strong enthusiasm to to practice in this field of law. And the second, you need to meet with lots of people from this field. For instance, in Uzbekistan, in Tashkent, my recommendation is to meet with practitioners, professors dealing with this arbitration cases. I don't know, in your country, in Tashkent, is there any specific arbitration law firm? And also my other recommendation is, during your studies, you can spare time to prepare articles, essays on international arbitration. If you have good essays, articles, and you can send these essays, articles in English to the law review magazines. There are lots of forums, Young Arbitration Review, and also exit Young Arbitration clubs, or ICC arbitration clubs, Young Arbitration clubs. So you can write essays on some specific issues about arbitration, and you can send these articles, essays, to these centers. And if they accept to publish these essays, this should be very helpful for you to attempt to start in these kind of law firms.
Thank you. By the way, I read your article about COVID-19 pandemics. I read, it was excellent, but I had a little bit questions about that article.
Of course.
During pandemics, at the moment, you counted that more than 3,000 or 1,000 of cases appeared, and I would like to ask, what are the cases mostly about? What is the mostly case about?
I see. As far as I remember, in my essay, we just mentioned the possibility of cases that can be filed. Not the existing cases, but there may be a possibility to file case against the states. For instance, one of them is about the measure applied by Spain. As you know, Spain has nationalized all of its private hospitals in the country as a measure of the COVID-19 pandemic. So I believe that if this nationalization will continue for an indefinite period, then the foreign investors in this country who own hospitals, private hospitals, may file a case against Spain for this measure, because first of all, you need to look at proportionality. Of course, a state has right to regulate public policy and public health measures, but if it goes with an uncertain period, then this action can be considered unproportional. And investment arbitration tribunals may rule that Spain should be held liable for such action. This is just one example. Another example is from Peru. Peru has issued an emergency decree suspending the collection of toll fees on the highway roads. There are private companies operating the highways in Peru, and Peru issued an emergency decree which suspended the payment of these roads. So the owners of these highways, operators of these highways, may also file case against Peru. Do you know GAR 100? GAR 100 is an important investment and also international commercial arbitration magazine. And in this website, when you look at GAR 100, you can see lots of news about arbitration. And also in that
research.
Yeah, and in that website, you can also see that even Peruvian officials stated that we have concerns for the future that these foreign investors may file case against Peru for such action. And also, you know, France, for instance, has seized lots of masks which should have been sent to Spain and Italy from a Sweden health company. So Sweden health company, for instance, filed a case against France for such confiscation of these gloves and masks. So these are specific examples. Maybe not 100 cases, but there may be some cases like the actions taken by Spain, Peru, or France. These are the issues that we highlighted.
You mentioned this. I read it. Actually, it was a really fruitful article for me.
Thank you very much.
Yeah, I then I planned to research the cases you mentioned in the article. Thank you. Actually, arbitration has the power of recommendation or just forcing. I think recommendation, right? I mean, the decisions.
You know, it is when if we just look at this from the exit convention, as you know, there are two important international instruments for the enforcement of the international arbitration awards. One of them is New York Convention.
The
Hague Convention is also important, but the New York Convention, as far as I remember, contains specific provisions which has also lots of members. There are approximately more than 150 countries ratified the New York Convention. So New York Convention says that each member states should recognize and enforce the international arbitration awards if there are in Article 5. I recommend you to look at Article 5 of the New York Convention. If the arbitration case was held within a due process, and if there are no international public policy rules which may prevent the enforcement of the award, if the rights of the parties to be heard were not prejudiced during the arbitration proceedings, if the arbitral award became finalized, then the relevant states courts should recognize and enforce the award. But in practice, we can see that lots of the national courts, if they don't want to enforce the arbitral award, they may find some reasons against public policy. And generally, these are not related to international public policy, but their national public policy. So, for instance, a Turkish court, if it does not want to enforce and recognize the award, it may find a reason, a public policy reason, to prevent the enforcement of the arbitral award. This is an unfortunate situation, but recently, the Turkish courts also started to look at international public policy reasons, not the national public policy reasons, to enforce the arbitral awards. ICSID Convention is different. ICSID Convention Article 54 states that if there is an ICSID arbitration award, state members should accept this award as if it was rendered by a national court of this state. So there is no recognition and enforcement stage for an ICSID arbitration award. This award should be considered as a national court decision and can be enforced directly. This is a very important point. And for instance, let's assume that Spain has lost a case against itself by an investor. If Spain refuses to enforce this award, the investor may enforce this award in any other country, because this award should become a national court decision, not only for Spain, but for all other member states. So what can investor do? Investor can find an assets of Spain in another country. For instance, Spain may have a plane, State Airways plane, in France. And the foreign investor can go to France execution bodies and ask them to attach Spain's plane in Paris.
Wow, understand. I didn't just mention, I wanted to ask this question. How can investor protect his rights in these cases? I wanted to ask, but you answered. Thank you for this. It was actually fruitful.
You can do it both in ICSID Convention and in New York Convention. For instance, if you are able to find some assets of a state or of the defendant in another country, then you can go to the court of this state. The only condition is the state, the third state should also be party to the New York Convention, or should also be party to the ICSID Convention.
Yeah, right.
If this is the case, then you can go to the court of this third party state, and you can ask your rights to enforce the arbitral award in that country.
Thank you. Actually, real. I got knowledge here. So, for as a per se experienced international private lawyer, what books do you recommend to read for every law student?
Yeah, I mean, there are lots of very esteemed professors, scholars in private international law area, and also commercial arbitration and investment arbitration. I can recommend you to read Gary Bourne Gary Bourne's books. Gary Bourne is a very well-respected scholar in international commercial arbitration. And also, I can recommend you other arbitration practitioners, professors like Julian Lew, L-E-W.
Julia.
Julian Lew, L-E-W.
Thank you.
Lucas Mistelis, and also Stefan Kroll. These are very important scholars, I can say, for the investment arbitration. I can recommend you to read Christopher Schroer.
I heard a bit about him, but
yeah, Schroer. When you write Schroer, you can see his books. He has lots of books in investment arbitration. Dolzer, Rudolf Dolzer. Rudolf Dolzer. He is also German. Rudolf Dolzer. He has just passed away, unfortunately. He has died 1 month ago. Rudolf Dolzer. You can also read their books.
Thank you. Actually, I got something.
Have you ever been in Istanbul?
No, but I was planning, but not yet.
I see. If you are planning, let me know.
Inshallah. Okay.
Inshallah.
Thank you.
If I come to Tashkent, also I can let you know.
Of course. I appreciate my teachers, as in Islamic quotation there is Ustaz otangdan uluh. In Uzbek it's like teacher is respected as a father.
Oh, thank you very much. Thank you very much.
I got a lot of things from you, actually.
Inshallah. I think you use also inshallah, right?
Yeah.
If God permits. Inshallah.
Okay. Actually, at the moment, whom do you recommend to her say follow? I follow you in LinkedIn.
Yes.
Actually, I watch your articles. Whom do you recommend to her say follow and see their articles in law and the sphere of this?
Yes. I recommend you to follow, for instance, Jean Paulson. J-A-N.
John Paulson.
Jean Paulson. Jean Paulson is a very famous arbitrator. I can recommend you to follow him, and also Jean Kaliki. Jean Kaliki, she is a famous U.S. arbitrator. So she is very famous. Also, I can recommend you Charles N. Brower. He is also very reputable arbitrator. And also Garavi. He's a Persian French arbitrator. Hamid Garavi. These people are very famous.
Thank you.
By the way, Emmanuel Gaillard. You should also look at him. Emmanuel Gaillard.
I have connection with him, but I will check. Emmanuel. Yeah. Thank you.
Emmanuel Gaillard.
Actually, thank you for fruitful talk.
Thank you, Sanjar.
I got, as I have mentioned, I got a teacher from a virtual teacher.
Perfect. Whenever you want, we can also discuss again. If you have any questions, you can send me through LinkedIn, and we will keep in touch.
Thank you for taking requests and having like this fruitful talk with you, because as I aforementioned, I'm going to do career in this path, uh,
Yes.
for of course for the sake of justice, for and someone should set justice in the world, right?
This is very good to see that you already determined your plan. This is very important, Sanjar, because lots of students, even after the graduation of law faculty, do not have any idea what they will do. So you already determined your plan. You already determined your path. So it is very good. And also, I believe that you will be a very good private law lawyer and international arbitration lawyer. That's why also I wish you a good luck in your
Thank you.
studies,
Thank you.
and also after graduation, good luck in your career. As I said, we can keep in touch, and also who knows, maybe we can also work together in the future
Inshallah.
in some arbitration cases. I'm very happy to support my young colleagues in this field of law, arbitration actually. I hope all is well. All will be well.
Can I ask one question? It is one of the most important one. In our university, actually, there is a hearsay. Given diploma like jurisprudence, and because of this, that we do not learn the specific subjects. We learn criminal law, family law, civil law. It's important. We learn this. And how do you think, for future international lawyer, are these fields important or not? If it is, I should pay attention.
I
How
see.
do you think? What the level
Uh,
is it to pay attention?
this is my opinion, Sanjar, that each national law about, for instance, civil law, family law, or criminal law should be well known by a lawyer, even if he is dealing with international law, because international law is directly related with national law. In each dispute, you will see some connection with some national laws. The international law should directly related with states and states' internal laws. So of course, one lawyer cannot know everything very well about knowing the national laws very well. Otherwise, there may be problems. For instance, in Turkish, we are studying civil law. We don't have common law. I don't know Uzbekistan. You have common
We
law
also
or
like
civil law?
this civil law. We got.
Civil law, right? Our
Yeah.
our laws come from generally from Swiss or Switzerland or France. So
Yeah.
the issue is, first you need to know your national law, but of course you don't need to memorize each law. It is not possible. But at least you need to know if there is an issue, to know which issue can be relied on, which specific law. So my recommendation is you can develop yourself in international law, but also you should know the exact general principles of your national law as well.
Thank you. Thank you. I will remember these recommendations. Thank you. As a teacher, remember me in your duas, with the dua of teacher.
Of
Students
course, of course.
develops. Thank you.
Uh,
Actually,
Thank you, Sanjar. I wish you good luck in your studies and hope to see you soon then.